Hello Con Law class, welcome to the summary video for week 4. In this past week we continued our discussion of federalism. And one of the first things we talked about was the 10th Amendment as a further restraint on the federal ability to regulate the states. And we said perhaps the 10th Amendment and the Commerce Clause are sort of two sides of the same coin of federal power, a power and a restraint. Although we saw in National League of Cities a 5-4 majority suggesting that yes, indeed, the 10th Amendment could be a substantive restraint. But then in Garcia in 1985, a different 5-4 majority really suggesting, overruling National League of Cities and then suggesting that the 10th Amendment is really not a very strong substantive restraint, that the primary restraint would be the political process. So we're left with a bit of a lack of clarity. We certainly want to use the 10th Amendment as we march through different arguments why a federal regulation may impinge on the states, but it seems from this line of cases that we have that it's unlikely to really have much teeth depending on the makeup of the court. We also talked about this idea of commandeering or anti-commandeering. We looked at this in the context of a nuclear waste statute, and recall Justice O'Connor's opinion suggesting that there is some limit on the ability of Congress to utilize resources of the state. At some point it's going to pass over into something we would call commandeering. But again, we don't have a really clear test or any kind of bright line to determine when that might be the case. It's another argument you kind of have to march through and look at the practical realities of what's actually happening in the case. We talked about the taxing power. We noted this is one of the key powers, one of the key enumerated powers that responds to some of the problems in the Articles of Confederation. We saw that there are some cases that seem to suggest that a tax could, again, cross a kind of vague line into being not a tax but really a penalty, and a penalty that allows the federal government to control the states in a way that would be improper. So we saw that in this Bailey v. Drexel furniture case. We saw other cases then after the New Deal seeming to uphold a broader extent of the taxing power. And you can see some of these cases as we move kind of before the New Deal and then moving into the New Deal. Again, not necessarily a really clear line, and things get even less clear when we get to the ACA case, in which Justice Roberts says that the shared responsibility payment, even though it's called a penalty in the statute, is in fact a tax. So again, another kind of piece of what you want to look at when we're looking at an overall regulatory scheme. At some point it may cross over and be a penalty, but it seems very unclear where that would be, particularly after the ACA case. We talked then about the spending power, and we noted that Congress has the authority to spend for the general welfare, and the question is, what does general welfare mean in this context? We looked at U.S. versus Butler and noted that the first Justice Roberts said that the spending power is an affirmative separate power, taking the Hamiltonian view rather than the Madisonian view, but without really laying out exactly what the limits of that would be. We do get a test in South Dakota versus Dole. So we have this 4-part test, and as I said in class, this is really should be really your go-to when we're looking at a spending power issue. We have the 4 parts of the test there. As we've noted, probably the first 3 parts in many cases are going to be relatively easy to fulfill, and often it's going to be that 4th part that might be an issue, whether it conflicts with some other constitutional provision. Though we could see, under the 2nd prong, a really vaguely worded statute. Under the 3rd prong, maybe a spending that's really not directly related to any kind of federal concern. Again, we saw this come up in the ACA case. We didn't see Justice Roberts in the ACA case apply the Dole test, but rather applied something called a gun to the head test, if we can call it that. Not really clear when it's a gun to the head, when it's a legitimate exercise. Probably best to try to apply the Dole test first and then maybe look at this gun to the head within the context of that Dole test or as sort of a fallback. We then looked at the Dormant Commerce Clause, and we said that the Dormant Commerce Clause is the fact that Congress has the commerce power, which is designed to sort of create a broad space of federal regulation of interstate commerce. So what does it mean if Congress doesn't act? If Congress does not act, what may the states or may not the states do? And as we look through a whole bunch of cases, we sort of summarize the modern approaches this way. A state law that facially discriminates against out-of-state commerce will be nearly per se invalid. The kind of category of exceptions that we saw are cases that we might call quarantine laws. And as we saw, it can be difficult even to figure out whether something should be classified as a quarantine law or an unlawful facial discrimination. We saw also that if the state is a market participant, then a law favoring the state is likely to be upheld, although we did see that we have to be very careful about trying to define the market. It's only the market in which the state is participating, not an upstream or downstream market that the state is trying to influence. Then we looked at state laws that are facially neutral, and we really saw two related categories of cases. There's a group of cases that will sort of generally look at the purpose or effect of the law and say if it has an impermissibly protectionist purpose or effect, it's likely to be struck down. And then we saw that there's a residual balance test, and it may be that the residual balance test really folds into this impermissible purpose or effect piece, or it may be that some cases kind of really look at purpose or effect without doing a careful balance, and then others will still look at a balance. But one way or the other, we're going to get to a balance test, and we're really just going to ask whether the burden imposed on interstate commerce is clearly excessive in relation to the putative local benefits. So as you see, this Dormant Commerce Clause is pretty powerful. It obviously doesn't mean that all state laws that have some effect on interstate commerce would be struck down, because many state laws, as we talked about in class, that have to do with commerce are going to have some effect, even just sort of generally on interstate commerce. But we at least have to look at it carefully and balance it out if we have a challenge. All right, so looking ahead to this coming week, we again have a somewhat shortened week because we have Rosh Hashanah on Thursday. But in class tomorrow, on Tuesday, we will finish up our discussion of federalism as we talk about the Privileges Immunities Clause and talk about preemption. We'll go through some cases. I have some examples that are kind of fun to play with on preemption. And then on Friday, we will get to the next portion of the class, which is separation of powers. We will dive right into some really meaty and interesting material on executive power. So I look forward to a good week, and I will see you in class tomorrow.